Okay, so let's finish this discussion about constitutional interpretation and look at some specific issues where the debate becomes very pronounced. But before we do that, I want to point out that this debate is really not about technology. People get very confused and they say, well, the originalists, their approach is really irrelevant because they can't deal with all of the changes in technology that have taken place since then, and they're really kind of just old-fashioned, stuck in the past, and it becomes makes the Constitution irrelevant for that reason. But this is really not the case. For instance, heat-seeking cameras, the kind of camera that you put on the bottom of a helicopter. You fly around looking for warm houses. And when you find a warm house, you assume that probably they're growing weed. And so police departments started doing this around the country. And the question began to arise, is this a violation of the Fourth Amendment, the freedom from unreasonable search and seizure? This is not a problem for originalists to apply the principle of unreasonable search and seizure to this new technology. It's not an issue. It's not a problem, and it's actually an issue on which both sides agree. Originalists and living constitutionalists agree. Yes, we have a principle that we can apply in current circumstances, and the principle really hasn't changed very much. We're to be free of unreasonable search and seizure. The question is, what's unreasonable? And in this case, both sides agreed. Heat-seeking cameras are unreasonable, so they cannot be used. But moving us from this question about technology, which really isn't an issue, some of the issues that really are quite heated are issues about, say, the death penalty, like we've already talked about. Does the death penalty violate the Eighth Amendment? Well, Scalia often brings up the issue of, putting someone to death for killing a horse. For stealing a horse, as an example of how the system has worked. But it's not that great of an example because nobody's suggesting, really is true, nobody's suggesting putting someone to death for stealing a horse. But more contentious debates where this has become important are questions about, for instance, putting someone to death who is under 18, or putting someone to death who is mentally incapable of making rational decisions. From the standpoint of an originalist position, this is not problematic because in the 18th century, these were not practices that were considered unacceptable, and so the idea is that the Constitution does not prohibit the death penalty in those cases. Living constitutionalists have disagreed on that and have said, well, today we think about things a little different and we consider it cruel to put someone to death when they're 15 or 16. Another issue where we've seen this is over the Confrontation Clause. This is in the Sixth Amendment to the Constitution, and it says that people accused of a crime in a trial have the right to confront witnesses against them. And the idea is that when you are in the same room with someone and you can look them in the eye, it can be very difficult for someone, if they're falsely accusing, to carry on with the false accusation. So along comes a case where there is someone who's accused of molesting a young child, and he is found guilty, and then claims that his Sixth Amendment right to confront his witness was violated because during his original case, they placed the child in a separate room to give testimony, and they were never in the same room together. Now, obviously they did that in order to, spare further trauma to the child. But his argument was that this violated his constitutional right to confront witnesses against him. The case came before the Supreme Court, and the two sides disagreed. Scalia argued that if any part of the Constitution is crystal clear, it is that part about the Confrontation Clause. And he said that in the 18th century, there were child molesters, and they did not provide an exception in the Constitution for such cases, and the Constitution does not require, and in fact prohibits, such an exception. So he argued that the child had to be in the court, and that the convicted molester's rights were violated. Breyer took a different position and said that there were two values at stake. One, the very important value of being able to confront witnesses against you, but also the value of maintaining the health and the dignity of that child. And that when you put those values up against one another, an exception to that rule can certainly be justified. So this is certainly a very different position that the two sides came to. Another series of issues has to do with the right to privacy. The right to privacy is not in the Constitution. It's a right that was added by the court in a case about birth control information. It's only applied in very few cases, like the question of abortion, birth control, and gay sex. And the originalists really dislike this notion of a right to privacy. They say it's fabricated, it's not in the Constitution, and that certainly the Constitution does not speak to the issues of either abortion nor gay sex. And that if states want to prohibit those activities of either gay sex or abortion, that it's certainly their prerogative to do so, and that's not prohibited by the Constitution. Living constitutionalists have come to a different position on that question, on those two questions. They are persuaded that the right to privacy is a reasonable interpretation of different parts of the Constitution, and that it does protect the right to an abortion and also the right for people who are gay to engage in sexual activities without threat of prosecution by state law. Really interesting debate. Another final one that I wanted to mention has to do with the 14th Amendment, which was put into the Constitution in 1868 to protect former slaves. And almost immediately after it was put in the Constitution, women said, "Oh, it says persons. I'm a person. Aren't I entitled to equal protection under the law?" And it wasn't until 1971 that the Supreme Court decided that, yes, indeed, the 14th Amendment does apply to women. And the same rationale was used to apply the 14th Amendment to strike down laws against gay marriage throughout the states. This is something that originalists have objected to, and have objected to, but not because they're opposed to those issues, but because they're not constitutional questions and that they needed to be settled through the legislative or through the amendment process.